Welcome to Juris Stupidity, a video podcast devoted to the use and misuse of legal terms and concepts in social and other media. The topic of this episode is appeal bond and stay. The term appeal bond is itself somewhat misleading. Generally, an appeal of a court decision or judgment can go forward without a bond. Most states, as well as the federal system, have short automatic stays, say for 30 days. And then after the automatic stay, a money judgment may give rise to legal actions to enforce the judgment so that funds can be collected from the losing party. In short, a bond is not needed to appeal a decision. However, to protect one's assets from collection proceedings on the basis of a court judgment during the time of an appeal, the party owing the judgment can move for a stay of those proceedings. A stay is a court order prohibiting attempts of collection. And a motion for such a stay is supported by the offering of a bond or surety, usually in the amount of the judgment plus other costs such as interest. This bond is commonly called an appeal bond, though its only relationship to the appeal is the time that the appeal is in process. Now, very recently, such bonds have been referred to as appeal bonds by commentators regarding the various multi-million-dollar bonds said to be required of Donald Trump to cover judgments while he appeals. To be clear, the bonds are not required for his appeals to go forward. The bonds are required to protect his assets from foreclosure during those appeals. Moreover, the bonds need to be approved by the relevant court. At the time of this podcast, a $175 million bond offered by Trump's lawyers is being challenged by the New York Attorney General and will soon be before a court for approval. This case will be governed by New York state law. Normally, I would recite the relevant part of that law here. However, in my opinion, the New York law on such bonds is dense and somewhat difficult to describe. But it essentially works the same as a more easily understood federal law governing the same topic. The federal law is captured in Rule 62 of the Federal Rules of Procedure governing a stay of proceedings to enforce a judgment. It states, at any time after the judgment is entered, a party may obtain a stay by providing a bond or other security. The stay takes effect when the court approves the bond or other security. So next time the subject comes up, don't be confused. An appeal bond is not required to appeal a decision. The appeal may proceed, but assets during such an appeal are not protected from collection. For such protection, it is required to get a stay. Got that?